Good morning. Today hearing is between the Karanveer Singh, who is the applicant, and the Minister of Citizenship and Immigration. The date of hearing would be August 8, 2020, and the place of hearing is Toronto, Ontario. The date of decision would be August 8, 2020, and the member who would be participating in this hearing would be Harpreet Olak. Minister's Counsel would be Chandon, and the claimant's counsel would be Ajay Chauhan.
This is an inadmissibility hearing concerning Karanveer Singh. This hearing is being held at the IRB office in Toronto on August 8, 2020. My name is Harpreet Alak and I will be deciding your claim. May I ask the claimant and the claimant counsel to stand up and raise your hand? Raise your right hand. Do you solemnly affirm the evidence that you will give shall be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Yes, I do.
Thank you. You may be seated. The climate is represented by Consul Mr. Ajay Chauhan in this hearing. We also have Mr. Chandan as the Minister Consul. I will ask number of questions during the hearing. My questions are for the purpose of gathering information to make a fair and informed decision. If a question is unclear, please say so and the question will be restarted and rephrased. We will start the proceeding now, Mr. Chandan. What is the minister's position today?
The ministry is seeking continued detention on the ground that the Karanveer Singh would be unlikely to appear voluntarily for an admissibility hearing.
Okay. Karanveer Singh, you are being detained by immigration authorities. The minister is seeking your continued detention. However, this hearing is for me to decide whether you remain in detention or are released. I am required to release you unless I am satisfied that you would be unlikely to appear for the admissibility hearing, talking into account prescribed factors. I will hear first from the minister, then from your counsel, and then I will give a decision.
Okay.
Go ahead, Mr. Chandan.
Thank you, ma'am. So, just a brief history on Karanveer Singh. He became a permanent resident on the 17th of December 2007 under a skilled worker category. On or about July 3rd, 2009, he was charged in Moldova with fabrication, possession, sale, or use of false official documents, imprints or seal contrary to Article 361(2) of the Criminal Code of the Republic of Moldova. These incidents are alleged to have occurred in July and August 2007 prior to his arrival in Canada. This is outlined on page 9 of the minister's disclosure. The amount of the fraud is allegedly $437,000 approximately US dollars. Again, that appears on page 9 of the disclosure. The maximum penalty for this in Moldova is 15 years imprisonment. That appears on page 8 of the minister's disclosure. Canada Border Service Agency has become aware in January 2011 that Karanveer was wanted in Moldova for fraud. When Karanveer Singh came to Canada, he originally lived in Toronto, but at some point subsequent had moved in northern Alberta. There has been a referral for an admissibility hearing signed. The hearing unit just got a copy of the file this morning, and we are in process of preparing a package for the admissibility hearing and would expect that could happen rather shortly. With regard to the prescribed factors under Regulation 245, the ministers acknowledged that the charges in Moldova were not laid until 2009, after Karanveer Singh became a permanent resident of Canada. However, the alleged offenses concerned in July and August of 2007 prior to his arrival in Canada. I would submit, therefore, that based on the timing of the alleged offenses, he is fugitive from justice in a foreign jurisdiction. As well, fraud and forgery are offenses under the Criminal Code of Canada. which is an act of parliament. There is information on file that indicated he does have strong ties to the community in Canada. It appears Karanveer has a child in Canada who perhaps is living with Mr. Karanveer's wife in Ontario. I understand applicant has been separated for several years as well. Karanveer, I believe, has a sister, brother-in-law, and two nieces in Fort McMurray. He owns a property in Fort McMurray and is apparently a part owner in a stream truck company in Fort McMurray. I would submit these are very good reasons why he would not appear for a hearing that could lead to his removal from Canada. Under the regulation 248 factors, I would submit that detention has not been in lengthy in this particular case because it's a holiday weekend. We are having detention review in just over 24 hours since he was arrested. As I indicated, the hearing unit is working on the hearing package. We would hope to have it ready early next week so that perhaps it could be dealt with a 7-day detention review if a 7-day detention review is necessary. Again, we would not expect detention to be lengthy once the admissibility hearing is dealt with.
Well, sorry, Mr. Chandan. He is a permanent resident of Canada.
Right.
So if he is found described in the allegation, he has a right of appeal.
Yes, ma'am.
And the standard of proof is higher with respect to permanent resident in 36(1)(c).
Yes, ma'am.
So I don't understand your length of detention argument.
Exactly. We wouldn't be looking to detain him any longer than it takes to get the admissibility hearing completed.
Well, okay.
So there are notes on the file that indicate current brother-in-law is willing to post a bond of about $1,000. That may be something the member wishes to keep in consideration, weighed against the amount of money that at least in the fraud and the possible terms of imprisonment currently may face if he is deported. And again, I acknowledge he has a right to appeal. Further to any question you may have, ma'am, those of my submissions.
Okay, thank you.
I'll keep my submission brief, ma'am.
Yeah, I had rather you just get two alternatives to detention because I'm not convinced that detention is necessary here. But I would like to see some more motivation for Karan Singh to appear for his admissibility hearing.
Yes, absolutely. In a sense of all the factors that my friend outlined for you, indicating that, you know, these are factors against him showing up are actually the same factors that I would rely on to indicate that he would, in fact, attend. Kanvi Singh intends to challenge his matter and will go about it through his legal representatives there. He's got a family in Canada, he got a child here, he's separated, but he is current on his child support obligations, which are $1,000 a month. He has a sister, her husband, and two nieces that lives with him. His sister is starting work in July. His brother-in-law is a truck operator. His family members in Canada have status here as well. His friend in Calgary, she is a CFO of a company, and she initially made contact with my office. As you outlined, ma'am, the key issue is this: is I don't understand the minister's position. If the minister is saying that they are not looking to detain past admissibility hearing, which will occur apparently within 7 days, then why would we detain him even now? Because even if the admissibility hearing occurs and even if is found to be described as a person in that report, apparently under 36(1)(c), he still has an appeal to the Immigration Appeal Division. So, if we were to look at the length of detention is potentially interminable because, well, no one can say how long it would be because you're looking at IAD appeal, right? And after that, you have got no extradition treaty with Moldova. Ultimately, what will assure you, ma'am, that Karmi Singh is going to attend a future admissibility hearing of or future immigration proceedings? It's because it would not be in his self-interest not to attend it. It would actually be self-destructive because convincing has the means of challenging the administrative action of the minister in a legal form, whether at the immigration division or whether at the IAD. Karnveer Singh is willing to surrender travel documents, is willing to provide a cash bond, he also willing to provide a surety against his property. His sister is willing to act as a bondable person. He's 39 years old. She's got no criminal record. She lives with him. She wouldn't be stepping forward if she didn't believe in her brother. She understands the significance of this responsibility and the consequences of the breaches of any terms and conditions. So, you got some before you who got this fixed address in Canada. He's been working for this one company making over 150 grand a year for 3 years. He's been living in this country for more than 2.5 years. There are no convictions here, and Minister herself admits that. The minister representative herself admits that they are not looking to retain past the admissibility hearing. So it makes no sense in my submission that we order detention when the minister is willing to apparently let him go after the admissibility hearing. Are we simply just punishing him? Preventative detention is not supposed to be used to punish an individual.
Okay, Consul, please you have got to stop with the speeches now because all I'm looking for is some specifics on the alternative.
$5,000 a cash bond I think is most sufficient. If you feel an additional bond is required, we can certainly look at the property. But I think the circumstances given the minister's own submission in this regard, a $5,000 should be more than enough to satisfy any concerns here.
Okay, whereabouts of the admissibility hearing will be determined in the future. Uh, I think it's likely that the admissibility hearing would take place in 7 days. Consul is going to want to see your disclosure and prepare to address it. So we are not looking at 7 days of detention here. We are looking at however long it takes for the admissibility hearing to get scheduled, proceed, and be concluded. I really agree completely with counsel here that detention is just not justified. All we need here is I just need a bond and 5,000 as far as I am concerned is satisfactory in these circumstances. He's got penalty of family in Canada. He's got plenty of family in Canada. The likelihood of him disappearing and going underground is very small because not only does he have a lot of connections here, but he has a case that is worth arguing. Plus, he has an appeal before the IAD if he is found described, and at the hearing, there is a higher standard of proof on the minister with respect to permanent residence, where the allegation is 36(1)(c). In spite of that fact, in spite of the fact that he can be described as a fugitive from justice, these are not matters related to violence or sexual offenses. This is fraud and forgery are the allegations here. So I'm satisfied that this is a proper case for release. Then between counsel and the minister's representative, the immigration division, the scheduling of admissibility hearing can be done at a later date. Okay, I am going to prepare the order and I will fax to the RCMP.
Thank you, ma'am.
Thank you.
Okay, thank you. This matter is concluded now.